Good afternoon, everyone, and thank you for attending today. As you know, we've recently reached agreements with several large corporations to provide them with standard employment contracts for all of their employees. It's vital to remember that although our clients have differing requirements, we must provide all of them with clear, effective contracts which are legally compliant. Today, I'm going to be talking to you about the drafting of post-termination restrictive covenant clauses. As you know, this type of clause restricts an employee's employment options after the termination of his or her contract with their current employer. The standard types of restriction fall into one of three categories. The first is the non-solicitation clause, which imposes a duty on the employee not to approach his or her former employer's clients or customers for a period of time after termination. Then we have the non-poaching clauses, which prevent an employee from taking other key employees with them to their new place of business. And finally, we have the non-compete clauses, which seek to prevent an employee from working for a competitor in a similar role to the one previously held after leaving his or her employment. Non-compete clauses are considered the more onerous of the three, as they potentially prevent someone from earning a living. The UK government is currently considering whether these types of clauses unfairly hinder employees from moving freely between jobs. But as we do not yet know the result of the consultation, we must consider the position as it is now. Whether a restriction will be enforceable or not will be determined on a case-by-case basis. The test which the employer must satisfy is that the restriction is necessary to protect its business interests. It is generally considered that a restriction for more than 6 to 12 months will be difficult for an employer to defend. The important point to remember is that in the event that an employee raises a grievance, believing that a clause of this nature is unfair, it is up to the employer to show that the restraint is reasonable. Please bear this in mind when you advise your clients about the different types of restrictive clauses. You will need to consider an employee's position within the business. For example, those clauses which are more restrictive may be upheld against senior as opposed to junior employees, as they are generally party to more sensitive information. I would like to point out here, though, that any clause which is unenforceable at the time an employee is taken on as a junior employee will still be unenforceable if that employee is promoted to a more senior position within the business. This was reaffirmed in the recent case of Bartholomew's Agricultural Food Limited versus Thornton. It was held in this case that a restrictive covenant in Mr. Thornton's employment contract, which he signed in 1997 when he began work, was void. In this case, the court was persuaded that the term was manifestly inappropriate for a junior employee. It further stated that if it was unenforceable at the time it was agreed, it remained unenforceable regardless of Mr. Thornton's advancement to a role where such a clause might have been regarded as reasonable. This type of ruling should be food for thought for employers when dealing with employees who progress through the ranks to more senior positions. I would suggest that in this situation, we advise employers that a practical solution is to reconsider the reasonableness of the restrictive covenant when the employee is offered a more senior role, and if it requires amending, making the promotion conditional on the employee entering into new terms.